You might know me from my research on argument structure or language acquisition, but today I'm going to talk about a research project on another topic that I've presented to a variety of audiences. Before I get to it, though, I wanted to ask you again, how many of you have submitted an abstract here? Okay, so few. Well, if you have or if you haven't, there's a set of guidelines. So when you're presenting your research to linguists, right, you need to follow these guidelines. And let's see what they say. So there's a whole bunch of stuff, you know, at the beginning, but the first thing that pops out that's really important is state the main point or argument of your presentation, okay? Then there's a bunch more stuff that they tell you to keep in mind. By the way, this is on the website of the LSA, so you can always go there and review it if you need to. And then they say, state the relevance of your ideas to past work or to the future development of the field. And then a bunch more then the punchline, state the contribution to linguistic research made by the analysis, okay? So this is what you do, then a bunch more stuff. This is what you do when you're presenting to linguists, and everybody who's here knows that, or you're learning that. That's like your main audience, right? In other words, the main thing you want to keep in mind for all of these things in red is, why should anyone care about your research? Why? And all of those things in red were like, what's important about my research? Why should you care about it? Now, that's okay, easy enough to do for linguists because we're all a bunch of linguists and we know what we care about, right? You know what we, because you're one of us, care about. But suppose you're asked to talk to another group of people, not linguists, okay? Maybe an English department. Some of the jobs that Karen's talking about might be in an English department. Or let's say a group of researchers from across the university, like let's say there's a job search and people come from other departments to listen to you who don't know about linguistics. Or maybe your audience, well, you know, maybe you're talking to the Rotary Club or to a bunch of high school students, right? So your question, the same question comes up. Who is your audience? And again, why should they care about your research? They're not linguists. So find out, you know, think about who they are and what their concerns are. And your goal would be to make your research grab this audience, whoever they are. So you need to think about who they are. If they're not linguists, chances are they're not going to care about what you care about, okay? They're not. So you're going to have to take your research, which is, so carefully packaged and beautifully organized, you're going to have to repackage it in a new way to make it interesting for that audience. You can't just drag out the same thing, even though it's perfect, you know, it's like it's really well done, but too bad. You've got to do another version. Okay. I'm going to tell you about a case study because I just had to do this. Here's an example of 3 different talks I gave on one topic, and I'll give you some background. As I said, I usually work on argument structure, but in 2012 I was contacted by the Massachusetts Bar Association. They are a group of Massachusetts lawyers who want to make jury instruction, and judges who want to make jury instructions easier to understand. Now, why do they want to do this? Because the current instructions are so confusing that verdicts are affected. And they wanted help from linguists because California used linguists to help them rewrite their jury instructions, and Massachusetts is a very competitive place. No. But I'll show you an example of a California instruction. Could I get somebody to read this, please? Can I have a volunteer? Thank you.
Failure of reconciliation.
No.
No. Failure of recollection is common. Innocent misrecollection is not uncommon.
You got that? Okay, so that's from the California Book of Approved Jury Instructions, from the old version of the old California instructions, which are very much like the current Massachusetts instructions. And this is just an excerpt. And they rewrote them with the help of linguists. Can I have your neighbor read this, please?
People often forget things or make mistakes in what they remember.
Okay, so that's the new version with the help of linguists. See what we can do into the world? And that's from the new Judicial Council of California Civil Jury Instructions from 2003. Okay, that's good. Anyway, I gotta do this. So you see what the problem is. Massachusetts has its problem. When they called me, I said, okay, we can't just start rewriting the instructions. We have to figure out what's wrong, what exactly is wrong with those old instructions. And, you know, I'm a psycholinguist. I know how to do research, so I said, we're going to do some research first. And I started a research project with a group of students, which is the Plain English Jury Instruction Project. And we wanted to try to figure out the linguistic factors that make jury instructions so difficult to understand. And did someone want to say something? From outside the room. Oh, okay. Want to come in? So the first results that we got from our project were presented at the 2013 LSA to an audience of linguists. And later findings we presented at the 2014 and 2015 LSAs in posters. The first one was a talk, a slideshow. And then I was asked to do a hands-on workshop, which was a 2-hour workshop for 35 judges in Massachusetts in a big, beautiful room, you know, had their attention, and it was great. And then we presented the findings at a conference, or a congress, I don't know what you call it. These are trial attorney consultants, and they're hired by attorneys to help them win cases. They're not academics, they're commercial people who are in business to help trial attorneys convince juries that their client is correct, is the one to, you know, to go with, okay? So it's a really non-academic group of people whose job it is to help the attorneys who hire them, and they make money doing this. Okay, they're not researchers. And they had a poster session for students, and one of my students submitted our work as her poster. Okay, and we did a poster and a handout. Okay, so these are the 3 venues that I'm going to tell you about. I'm going to start with the linguistics presentations. Which, you know, this is home territory. And this was the first slide from my 2013 talk, you know, the usual thing. And you remember those LSA guidelines I showed you before in the red, you know, that was pretty easy. I know what everybody who's in linguistics wants to hear, and I know how to make you think it's great research. And the first thing you want to know about is what are my hypotheses, right? And so I give you my 3 hypotheses. The first hypothesis is that the plain English instructions, the new ones, are going to be easier to understand than the original ones. You know, and if we take our current Massachusetts instructions and we rewrite them the way California did, and we rewrote a pilot group of 6 or 8, and we test subjects, we should get better comprehension on the new ones, the plain English, than on the current ones, or the original. And then we have these other 2 hypotheses that I don't have to talk about, because then you want to know my results, right? So if we ask how many of the questions when it got above the border, the sort of level of 90% of the subjects correctly understanding them, and guess what? We got really nice results, right? Only 30% were understood by 90% of the subjects when they were the current instructions, and we got them to increase to 52%. Still not very good, but better. In fact, so much better that the p is less than 0.0049. So all of this is what you put in a talk for people in your own field who know what p-values are and so forth, okay? All right. So the take-home message for the linguists was, oh, and then we also showed the linguists the next year and the year after. We showed them not just that we got better results, but what was it that made the hard instructions hard and the easier ones easier. And so here's a simplified version of one of the graphs I showed. We had 6 instructions on the left, okay? And you can see they're numbered 1 through 6, except they're not all numbered in a row because 3 and 6 were the hardest ones, and their scores, oh, I can use your thing now, right? I can use this. Look. Okay, green button. So you can see these guys were harder to understand on the right side of that dotted line than those, right? Because their comprehension scores were lower. And guess what? Those were the same 2 instructions that had very high rates of 2 linguistic factors, passive verbs and what we call legalese terms. We also call that presuppositions. So if you presuppose that your audience knows what the preponderance of the evidence is, and they don't know that, they're going to be stuck a little bit, So the instructions that had the higher numbers of passives and legalese were harder for them to understand, the jurors to understand than. We didn't test jurors, we tested Northeastern undergrads, but nevertheless, okay. All right. So you can see we got this nice inverse correlation, and that's what linguists care about. Psycholinguists especially. Okay. Let's see, where am I? Okay, good. So next. The next group we talked to were the judges, okay? And what do they care about? Well, they're the ones who give instructions to the jury. And they care whether the jurors understand them. They want the jurors to understand the instructions. So they're curious about this. They'd like to know what makes a difference. So in that sense, they're not that different from linguists, okay? But they don't know anything about linguistics or language, So you have to package it differently for them. So what we did is, we took one of those 2 difficult instructions I told you about, number 3 and number 6, and we showed them all the things that made this difficult. This is number 3, standard of proof. And we had like 6 semantic things that made it difficult, and 5 or 6 syntactic things. And I'm just going to show you a couple of those. So what you can see in the pale blue, I get to use this again, over here. So you see over here, these uncommon words, these very rare formal words like stringent and sought and notwithstanding, here they are in blue. There are several of those in this current jury instruction, okay? Another thing that we point out in the semantic domain is this presuppositions. These purple things are introduced as if we should know what they are, like a civil case. When I started doing this research, I didn't know what a civil versus a criminal case was, because I don't watch TV. So I didn't know there were 2 kinds of cases, but it's as if everybody's supposed to know that. The standard of proof in a civil case. Well, what the hell, you're talking as if I know what a civil case is. I probably should have put standard of proof in purple too, right? Okay, so there's all that, which people are expected to know, but they might not know. And then, just to move on, not go through all of them, but to move on to the syntax. So we looked at we showed all the passive verbs that are in this particular jury instruction. There are 11 of them in these 4 paragraphs or something. That's a lot of passives. And then, you know, we also, in addition to interruptions, which kind of break up the syntax of the sentence and the flow, there are at least 2 places that have 4 and 5 relative clause within relative clause within relative clause deep, okay? So you've got these 4 and 5 clause. I'm not going to ask you to read this, but, you know, they're really hard to parse, okay? And that causes people to really not understand what's going on. So we rewrote the instructions, and we showed the judges what would happen, what we did. And if you look at the new version, there's no pale blue, and there's no purple anymore. Okay, it's gone. And guess what? There's no orange, no passive verbs in the new version either. So these judges started to get really excited because in Massachusetts, judges are allowed to write their own instructions, unlike California. And then, so they were like, oh, wow, we could do that. So we gave them the other hard instruction, number 6. Okay, and we said, okay, now it's your turn. And we put them in groups, and we gave them these, you know, pages with blank space on the right to redo the instruction, and they had to sit there and work on it for a while. You know, we had 2 hours with them, so we let them roll up their sleeves. And by the end, they really appreciated how complex the language is that they use, and they kind of got an appreciation for what made it hard for jurors. And they found that writing their own instructions was practically impossible. They were arguing. It was a free-for-all. It was really a crazy place. But it was really good because that kind of a presentation it had some of the elements that the linguistic presentation had, but it also had some other things sort of tailored to them. Now, the trial consultants were sort of out there, you know, like I didn't know what to expect from them because I'd never been to a trial. I didn't know what a trial consultant was, and this was a conference, so I thought it was going to be like a academic conference. Well, it was not an academic conference at all. We were at a convention, essentially, and the poster room was very busy with all kinds of other stuff going on, and there were 4 students who were presenting posters. We did not have the luxury of anybody's really full attention. We didn't have 2 hours with them. We wanted to give them a take-home message that would interest them, but we also wanted to show them our work, and this was really a challenge for us. This was our LSA poster from 2015, and I thought, you know, if somebody should really care about what we're doing, maybe we'll just put this up there and we can walk them through little bits of it, and, you know, the people who come over will just explain what we're doing. But then, we created a handout from it so we could give it to them to take home if they really wanted to understand it, because we didn't want them to think we were looking down at them, right? They're not academics, but we wanted to give them the whole story. But at the same time, we presented on the back side of the poster another handout that basically said, it's called, what was that again? Getting your message across to jurors. What does linguistics tell us? So this was kind of a few tidbits from our research about what it is that jurors find difficult. For example, 50% of the jurors who were tested in one study could not define speculate. They thought that a preponderance of the evidence meant either a slow, careful pondering of the evidence or looking at the exhibits in the jury room. Okay, so this is what the trial lawyers are up against, and these people are advising the trial lawyers. So we just thought they should know about juries. Okay, so we started to tell them some of this stuff. We also told them, we showed them some before and afters. We showed them the one that I showed you before at the top, the California too, and we gave them some others. And then we talked about legalese and nominals and passives and stacked negatives that, you know, other syntactic constructions that make, we gave them examples, that make language hard. So if they're trying to talk to jurors, they should avoid that kind of language. And then we also went down here, I'm going to use this again, and we said, look, you know, how else can linguists help attorneys? Like, what is it that we can do for you? And we pointed out, in addition to the stuff with these jurors, we said, look, you know, there are times when there's ambiguous language in a contract. Linguists know about ambiguity. Linguists know about fuzzy terms. They know about trademarks, what's trademarkable. They know about authorship. Sometimes they can tell if the document's been tampered with. Plagiarized. They can make legalese into plain English. They can clarify interpretations when a text is disputed. And I can't read the one on the lower left, vague language, okay? So we just kind of wanted to give them the gamut of things that linguists might be good for. Now, of course, they get paid for what they do. They're not going to subcontract to us, but you never know. They might need credibility one day, and if they have to say, well, yeah, you know, and what I'm telling you has been supported by Professor Randall at Northeastern University, so they'll call me, or my student. Okay, so, that was the most successful part of the, you know, the handout, I think. So let me give you the take-home message. The take-home message is, you should stop worrying that people are going to get every nuance of your wonderful research. You know, it doesn't matter. This is what Karen said too. It doesn't, you know, your expert fan club, your small little coterie of people who are working on what you're working on, you'll be talking to them. That, you know, that's not what your presentations are about. Your presentations are about other people. And the question is, who are they? And why should they care about it? Okay? Yeah. So that's what's going to make an impression on them, because you're going to hit what they care about. And for judges, you know, we tried to do that. For trial consultants, we tried to tell them what would help them win cases. And that's basically the message. That's what we both said. And I want to just thank my team of wonderful research assistants who helped do this research and make it happen. And if you read the captions, you'll notice that we have students from diverse areas whose perspectives, coming from the law school or from the, you know, international affairs or the criminal justice department, really helped me do this job, reach other audiences. So I want to thank them. And we have time for questions.